Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk. We have a lot of information on the docket today. First, the Jennifer Dulos case update. Second, Jeffrey Epstein won't be able to go home to his Upper East Side mansion, so that federal detention facility is going to have to do. Bianca Devins, accused killer, is charged with murder. An update on the Savannah Spurlock case in Kentucky. We're going to answer a question that a subscriber sent to us, and we will get to the heart of this no controversy. Let's talk about it. Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk. We appreciate you watching our channel, and if you like what you see, please hit the subscribe button. If you like the video, please hit the like button, leave a comment, and if you want to be notified of future notifications, hit that little bell so that you get information and updates regarding new content and when we go live. So first thing on the docket today is we have an update on the Jennifer Dulos case. For those of you who do not know or not recall the Jennifer Dulos case, she is a mother of 5. She went missing. The last time she's been seen was May 24th. It is believed that Fotis Dulos, her husband, is a suspect, along with his then girlfriend, Michelle Troconos. Fotis Dulos and Michelle Troconos have both been charged with the tampering of evidence and hindering prosecution charges. Both have entered a plea of not guilty. Ms. Troconos has proffered with the police, and her attorney is quite confident that she has an alibi and these charges should be dismissed. What's interesting about this case is that no murder charges have been filed. It's believed that Mr. Dulos was believed to have been dumping trash bags around a town in New Canaan, and that he would have, and that the bags contained what police believe to be blood of his wife, Jennifer Dulos. They haven't found Ms. Dulos. Ms. Troconos apparently has cooperated, even taken the police into the woods around the home that she was sharing or visiting with Mr. Fotis Dulos. No charges. There's no body. Fotis Dulos and his attorney have done a pretty, I wouldn't say excellent, but they've given a pretty good effort to basically suggest that Jennifer Dulos basically disappeared on her own and she's not really in any danger at all. And when you don't have a body, we've talked about this, whether it's the case that we have here in Colorado, Patrick Frazee. If you don't have a body, you always have to say, are we absolutely certain that somebody's deceased? Unless you can have somebody testify to it and testify as to the remains, where they are, what happened to them, it's very difficult. My clients, not necessarily in homicide cases, I'm sure I'll offend somebody out there because I have managed to offend just about everybody on a daily basis, at least one. There's a quote, you hear it in the jails all the time. No face, no case. What does that mean? If somebody doesn't show up and testify, there's no case because they need that individual to come in and say, that's the person that committed the crime against me. Obviously, that's difficult in murder cases because you don't have that, but all the more reason you need to show that somebody's deceased. We will see how that plays out here in the next couple of weeks. Eventually, the prosecution's going to have to charge something or everyone's going to have to go back to basically their normal lives. Mr. Dulos doesn't have contact with his children, so people's lives are being affected, and the court's not going to drag this on indefinitely for the police to do something. They need to decide what they're going to do and move along. The next matter on the docket is that of Jeffrey Epstein. He is the hedge fund manager turned sexual offender turned world traveler who is now back in federal court in New York, facing very similar charges to what he was facing in Miami years ago, back in 2002, based upon some new information that was brought out by investigative journalists. Well, Mr. Epstein is in custody his attorneys have been trying to get him out on bail. You hear of a lot of cases in the federal system where clients are detained. Now, normally, for example, if it's a drug case, there is what they refer to as a rebuttable presumption. And the presumption is that if you're charged with a drug case over a certain amount and the penalties carry minimum 10 years to life under the Bail Reform Act, that individual is presumed to be a danger to the community and a flight risk. And the defense has to overcome that to show that they're not, to be able to have somebody released. Mr. Epstein's case does not have a rebuttable presumption, but he is charged with basically sex trafficking of young girls. And he travels a lot. He has a lot of wealth. I believe they estimate his wealth to be roughly $500 million. He has access to multiple private jets that he owns. Apparently, when they searched his Upper East Side home, they found in a safe or somewhere in the house a stack of cash, some loose diamonds. They found a passport that did not have Jeffrey Epstein's name on it, but it was his picture. It was expired, but clearly shows somebody trying to maneuver. Now, the government, for all those reasons, said that Mr. Epstein should be detained in custody pending trial. Now, Mr. Epstein's attorney, and whether you agree with him or not, you have to admit they were engaging in some very good advocacy for Mr. Epstein. The first argument made was that the fact that Mr. Epstein is wealthy does not mean that he somehow has to overcome this irrebuttable presumption that because he has means that he is going to flee the United States. It does not mean that at all. Mr. Epstein argued that that was not the case. In fact, what he simply meant is that just because you have money doesn't mean that you are a greater flight risk or danger to the community. In fact, Mr. Epstein said that he would be on a ankle monitor. He offered to have private security at his house where he would be residing pending pretrial conditions, and that no one would have any concern as to his whereabouts at any time during this process. The next argument was that Mr. Epstein has been in this position before and did not run. Well, things were just a little bit different there. Although the Florida case, he received a very favorable disposition whereby he received state prostitution charges versus federal child racketeering or child exploitation charges. Big difference in consequences. He basically received a very short jail sentence where he was granted work release. But he was not looking at the possible consequences now of some 40 plus years in prison. And given his age, it would be more than likely he would be a old man if he survived and he received the maximum sentence. The government was concerned that Mr. Epstein's wealth of what it was, and they argued, hey, if you really want to find out what Mr. Epstein's wealth is, then let him out and he'll help you walk through it. Mr. Epstein has a brother who has a net worth of some $100 million. He offered to co-sign on the bond, which if Mr. Epstein did not appear, his brother would have to be responsible for any bond amount. And that is an argument that is made in courtrooms every day. If a parent, a family member is willing to put their house up, someone is simply not going to leave the country because of that. The other argument made by Mr. Epstein's attorney was that there's actually data out there that says that the recidivism rate for sexual offenders is not that high, and therefore we should basically give the benefit of the doubt to Mr. Epstein. Mr. Epstein's lawyers tried to rebut the fact that there was speculation that Mr. Epstein had paid off witnesses who had either cooperated or avoided providing testimony. Said that's simply not the case, and that these were legitimate payments made to family and friends and workers over the course of the time, and nothing should be read into that. As it related to the passport that Mr. Epstein had of this Austrian passport that didn't have his name on it, he's just simply said that he used to travel extensively, and being a very religious man in traveling in the Middle East as a Jewish man, it wasn't safe for him necessarily to have an American passport. Obviously, the court was concerned with that. And ultimately, what Mr. Epstein's lawyer simply said is he is not a flight risk. He's been through this before. He was never a flight risk. He should be given a bond or some sort of collateral, a heavy collateral with that bond, so that if he does fail to appear or flee the country, that he would lose everything. The court rejected that and basically said this was a condition that he simply could not ignore, and that is safety to the community. Certainly, flight risk has to be a concern. When you have those types of resources, whether you think you can beat the case early on, if things change, people will want their freedom and they would jump on their private jet and be on their way. We'll see how Mr. Epstein's case turns out. My suspicion is that he will take some sort of a plea, which will guarantee at least he will have sunlight at the end of that tunnel and get out someday, but we'll see how things shake out. Not familiar with the intimate details of his case, but there are lots of young girls who are now young ladies, young women who are prepared to testify against him as to the massages that they were providing Mr. Epstein. We'll see how that one shakes out. So the next matter on the docket is the case of Bianca Devins. This is another weird and tragic case. Bianca Devins was purported to be some sort of internet personality, had a lot of followers, and apparently she was dating someone that she had met online, apparently a fan, and his name is Brandon Clark. These two had been dating for about the last 2 months. Well, it's alleged that Mr. Clark killed Miss Devins and posted pictures of her deceased body onto Instagram. He thereupon then tried to cut his own throat, also taking selfies in the process. Well, he survived, and now he's been charged with second-degree murder of Miss Devins. Such a tragedy. It makes no sense whatsoever, and the police have no motive as to why Miss Devins would have been killed, other than perhaps she may have kissed somebody at a concert. Absolutely crazy that that's why someone would have to lose their life. We'll be following that case as well. All right, the next matter on the docket is the case of Savannah Spurlock. For those who do not recall or are not familiar with this case, Miss Spurlock lived in Kentucky. Miss Spurlock was last seen leaving a bar in Lexington, Kentucky on January 5th. She hadn't been seen since. All of these individuals that she was seen on video leaving the bar with had been interviewed, and no one was charged. On July 10th of this year, the police were contacted because they smelled a weird odor coming from a property. Well, this property happened to belong to the parents of David Sparks. David Sparks is one of the 3 men that Miss Spurlock was seen leaving the property with back in January. Mr. Sparks has been arrested, charged with abuse of a corpse and tampering with evidence. The matter has been referred to a grand jury, and he is apparently the only suspect when it comes to the murder of Miss Spurlock. But as of the taping of this, no charges have been filed. Is anyone really surprised that one of the last 3 individuals she was with had something to do with this? Not surprised at all. All right, the next item on the docket is we have a question. And I've received this question quite often, so I figured let's just get it out there and answer it. And this question comes from Crystal, who is a subscriber in Canada. And the gist of her question is that why are so many people eager to talk to the police when the police are advising you of your Miranda rights and letting you know that you don't have to speak with them? Well, Crystal, if only I knew. I have begged with people. I have told people, as their attorney, do not talk to the police. All they have to do is say, I want to talk to my lawyer. Those are the magic words where questioning would have to stop. That's it. Now, most people know the general advisement from TV about Miranda warnings, all right? This warning doesn't exist in the Constitution. It was basically judge-created law, back in the late 60s on Miranda v. Arizona, and it said the police have to come up with some sort of advisement. And over the years, what's developed is the general Miranda warning. And it says that if you are going to be questioned by the police, that you have a right to an attorney, and anything that you say can and will be used against you. And sometimes people think, well, it only matters what I write down. It doesn't matter what I say. Completely wrong. It totally matters what you say to the police. What you write down, that's just icing on the cake for the police. And I'm not saying anyone should go out and commit a crime to test this, but if you're ever questioned by the police, you don't have to talk with them. Bottom line, okay? My experience as a criminal defense attorney is that most clients or defendants that are convicted get convicted by their own words. Their own words come back to bite them, all right? I've had clients that want to go in and tell something and they think it's the truth and it's going to set them free. It doesn't. It just simply helps corroborate what the police were thinking. Think about it. If you were accused of a crime and the police officer says, you did A, B, C, and D, and you said, no, that's not true. Let me talk about it. I did A and B. Those are true in your allegations, but C and D are not. The police look at it as, well, guess what? He just corroborated the complaining witness's story as to A and B, so he must be fabricating his denial to C and D. We're going to arrest you. Happens all the time. Now, the other question that I guess asked all the time is, I got arrested and nobody read me my Miranda rights. Well, guess what? If you get arrested, the police come and pick you up on a warrant. They throw you in the backseat of the car and they said, we're arresting you on a warrant. They take you to the police station. They book you in. You bond out. They come and hire their lawyer and say, I got arrested. No one advised me of my Miranda rights. Guess what? Doesn't matter. You only have to be advised of your Miranda rights if two things take place. One, you're in custody, and two, they're interrogating you about the question, about the crime for which you're under investigation for. So going back to the example, the guy that's sitting in the back of the police car, if he says spontaneously to the officer driving him down, oh, I bet this is about that thing that I did that was probably illegal. Guess what? No Miranda advisement necessary. What the defendant in the backseat said is completely admissible as a spontaneous admission. And I guarantee you that police officer will write it down as to statements that were made in the transport of the defendant. All right? So, yes, Crystal, I'm not sure why everybody talks. The police are practically giving you a warning not to talk, to get a lawyer, and any lawyer worth their salt is going to tell you to shut up unless and until somebody with authority to offer you some sort of immunity, usually an attorney or a United States attorney, can be available and let the attorneys talk. The police have no authority to make deals with defendants. They can't make them promises because they can't keep them. That goes to, well, basically, I've had cases thrown out where detectives will make promises to get you treatment, get you help, but first you have to tell us what you did. Psychological coercion, boom, statements thrown out and a motion to suppress. So, Crystal, I hope that answers your question. Now, the last thing on the docket is apparently something got out that there was some sort of controversy. Other YouTubers. At this time, we don't have any plans to do any collaborative videos with anybody. There's no debate to take place regarding anything. Specifically, people that would like to talk about the Christopher Watts case. People have their beliefs as to what happened. People have their beliefs as to what they think the evidence could be. I like to deal in facts. I like to deal in what is evidence that would be admissible in court and could actually go to prove whether somebody had done it. Yes, we were the ones that initiated kind of the investigation as it relates to was the emails from Nicole Kessinger to Christopher Watts, what started this whole tragic event set in motion. Totally believe that. Do I believe that Nicole Kessinger and Chris Watts had an affair? Absolutely. Do I think that she wanted to be the new Mrs. Watts? Absolutely. Do I think that she said, boy, it'd be a lot easier if your wife is no longer around and it can just be the two of us, and boy, it's, kids are expensive and apartments are expensive. Yes, all those things. Do I believe, do I know that Ms. Kessinger said anything that she directed Mr. Watts to do anything? No, I don't. No evidence whatsoever. Watts has stated he acted on his own. Yes, she may be perceived as a horrible human being. And for those who think that I'm somehow representing Nicole Kessinger, no, I am not. If I was, I would let you know. And I'm just trying to lay out the facts here. Bottom line. Did they talk the evening before? Yes. Did they go on their date? Yes. Now, do I see two people in the video? No. Do the investigators see two people in that video? No. And some people say, but her phone pinged in the early morning hours. Yes, I believe it was at 6:14 a.m. Okay. But guess what? It's on a cell phone tower in Frederick. It doesn't mean that she was in Frederick. It just simply means that she was on or about near that tower. She could have been going to work. But the fact that people want to leave out is that Chris Watts was already on his way out to the well site at 5:32 a.m. So almost 45 minutes later, she's in the area that could be literally driving up the highway on I-25 North. It doesn't prove anything. You may want it to, but the fact of the matter is, being in the area some 45 minutes afterwards doesn't necessarily mean that you participated, knew about any of the murders that had taken place or were going to take place when Chris Watts spoke to her earlier that evening. No evidence whatsoever. That's what I deal with. Facts, not speculation. Those videos by other YouTubers, I don't believe shows anything that they're purporting it to be. For someone to speculate that the gait of somebody walking is that of a female, that would be expert testimony, okay? And guess what? Under the rules of evidence, that testimony is not coming in because it's not based on science. It's just somebody's opinion. It's an argument that could potentially be made to a jury. As a defense attorney, it would be hard to argue that. A prosecutor is not going to go in to court on a theory hypothesizing that the gait of somebody's step is that of a man or a woman. When the pixelization becomes so bad when one zooms in, they're not going to do that. When you zoom out and you can't see two people, that's what a jury is going to see, ladies and gentlemen. So I appreciate the passion. I appreciate the need for closure, but my opinion remains the same. There's not enough for Nicole Kessinger to be charged. Will my opinion change if there is new, credible evidence? It might, but as of right now, there's nothing for her to be charged on at this time. That may upset a lot of people, but that's my opinion based upon the facts that we know at this point. So I hope you like the video. I hope you continue to watch. I hope you subscribe, and I hope you leave a comment. Have a great day.